Morning all. I think yesterday till president's rule, all those things we have discussed. Now let's start with under the first major topic of constitution, historical underpinnings, features, provisions. The most important topic, which one? Fundamental rights. We have already mentioned. Okay, we'll write the questions. First, let's note down whatever mains content which should be there with respect to fundamental rights in your notes. Quickly, of course, the most first constitutional aspects. Part 3, Article 12 to Article 35. Article 12 to Article 35. Inspired from US Bill of Rights. 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 Famously called as what? Famously called Magna Carta of Indian Constitution. Famously called Magna Carta of Indian Constitution. Magna Carta of Indian Constitution. So only will quickly sum up. Then put it as something like significance of fundamental rights. Significance of fundamental rights. Of course, some 5 major point 5, 6 you write. Significance of fundamental rights. One, exactly, promotes equality. Promotes equality. Prevents arbitrary power. Prevents arbitrary power. Prevents arbitrary power. Then upholds secularism. Upholds secularism. Upholds secularism. Then protects rights of minorities. Protects rights of minorities. Protects rights of minorities. Then supports rule of law. Supports rule of law. Then protects dignity of an individual. Protects dignity of an individual. Dignity of an individual. That's largely a kind of feature significance one. Same way below, features. Features. Very simple. Normally, directly you will not get a question. If in case whenever you are writing those points or answers on your fundamental rights, you may have to use this thing. That's it. Available to both Indians and foreigners. Available to both Indians and foreigners in bracket except, obviously, 15, 16, 19, 29, 30. Except 15, 16, 19, 29, 30. 15, 16, 19, 29, 30. Then negative in character, negative in nature. Negative in nature. Negative in nature. Then not absolute, qualified. In other words, reasonable restrictions. Not absolute, it is qualified. That is balance between individual freedom, social stability. Balance between individual freedom and social stability. Balance between individual freedom and social stability. Individual freedom and social stability. Fine. The next one, not sacrosanct. The words can be amended. Not sacrosanct can be amended. Sacrosanct can be amended. Then justiciable. Only keywords can be amended. Then justiciable. Justiciable. Yeah, largely these are the points. And then obviously we will not write each and every fundamental rights because that's not necessary. Broadly put it, 6 fundamental rights. 6 fundamental rights. Right to equality, 14 to 18. Right to equality, 14 to 18. Right to freedom, 19 to 22. Right to freedom, 19 to 22. Right to freedom, 19 to 22. Then right against exploitation, 23, 24. Right against exploitation, 23, 24. Right to freedom of religion, 25, 28. 25 to 28. Right to freedom of religion, 25 to 28. Then rights of minorities, 29, 30. Rights of minorities, 29, 30. Then constitutional remedies, right to constitutional remedy, 32. Right to constitutional remedy, 32. Yeah, now whichever is important for means, those aspects will stress more on. Fine. Yeah, first one obviously most important one, article 19. 14 normally they have not asked a single question. Right to equality aspect is there, but that will discuss under your comparison of constitution. 19, to be more precise, 19 clause 1 subclause A. 19 clause 1 subclause A, freedom of speech and expression. So anytime, because at least for argument's sake, everything you will have to obviously know about it. Very simple, nothing new obviously. Just broadly tell what does that mean. Freedom to express one's own view as well as that of others in any medium, through any medium. Freedom to express one's own view, opinion, freedom to express one's own view as well as that of others. One's own view as well as that of others through any medium. Through any medium. Obviously what below? Through any medium. Supreme Court has given broader interpretation. Supreme Court has given broader interpretation. Supreme Court has given broader interpretation. Right? Of course, some major ones you write below, because that cases also sometimes when you write your answers you have to include them. First one, freedom of creative expression. Freedom of creative expression. Yes, Rangarajan case. Freedom of creative expression. Yes, Rangarajan case. Freedom of creative expression. Yes, Rangarajan case. Then freedom of press. Freedom of press. Romesh Thapar case. Freedom of press. Romesh Thapar. Romesh Thapar case. Romesh Thapar case. Fine. The next one, right to protest. Right to protest. MKSS, Mazdoor Kisan Shakti Sangathan. MKSS case. Mazdoor Kisan Shakti Sangathan. MKSS case. Even PUCL is also there. MKSS case. Then, right to or freedom of silence. freedom of silence. Vijo Emmanuel, Jehovah Witnesses. Freedom of silence. Vijo Emmanuel. Pijoe Emmanuel. Emmanuel. Vijo Emmanuel. Then the recent in the sense, of course, the very famous one, right to internet, Anuradha Bhashin case. Right to internet, Anuradha Bhashin case. Jammu Kashmir ones. Right to internet, Anuradha Bhashin case. The others are there, but it's fine because we may not discuss everything. Then reasonable restriction. Reasonable restriction. Because mention that sovereignty, integrity of India. Sovereignty, integrity of India. B. Security of state or security of India. Security of India. C. Friendly relations with other countries. Security of India. C. Friendly relations with other countries. Friendly relations with other countries. 4. Public order. Public order. Then decency or morality. Decency or morality. Contempt of court. Contempt of court. Incitement to an offence. Incitement to an offence. Defamation. Contempt of court. Incitement to an offence. Defamation. Defamation. This is your reasonable restrictions. Fine. Then other ones obviously are whatever assembly, association, all of them from the mains angle, not very important one. So next important is which one? Okay, 20 if you want, you can mention few because preventive detention, those aspects will be there. Maybe here and there for your arguments, it might help. Article 20, whichever is important from mains perspective, we are noting it down. Article 20, protection in case of conviction for offences. Protection during conviction, in case of conviction for offences. Case of conviction for offences. Of course, what you have, 3 provisions. So 3 components actually, 3 components. Very basics, obviously you know this. First one, A, no ex post facto law. No ex post facto law. No ex post facto law. In simple terms, what does it mean? No retrospective application in criminal laws. No retrospective application in criminal laws. Again, they tell trial procedures can be retrospectively applied, but all of them, that's all prelims part, not necessary. No retrospective application of criminal laws. So that's more than enough. Exceptions, everything, that's your prelims angle. That 2 is what then? No double jeopardy. No double jeopardy. You know that no person can be punished or prosecuted for the same offence more than once. 3. No self-incrimination. No self-incrimination. No self-incrimination. However, accused can be forced to collect. However, accused can be forced to collect signatures, blood samples, fingerprints, etc. Can be forced to collect signatures, fingerprints, thumb impressions, blood samples, etc. At the landmark, because this any time, whenever there is an issue in news, because last year also there was some, I think in Patna High Court or somewhere, some narco analysis issue was there. Not a landmark one, but whenever the time comes at least. Yes, Selvi versus State of Karnataka. Yes, Selvi versus State of Karnataka. Yes, Selvi versus State of Karnataka. Yes, SLV versus State of Karnataka. You know that. Please mention the landmark one. Narco analysis or polygraph tests. Narco analysis, polygraph test, brain mapping. Narco analysis or polygraph test or brain mapping cannot be directly conducted by police. Polygraph test or brain mapping cannot be directly conducted by police. It violates no self-incrimination. It violates means you cannot force someone to act as a witness or evidence against themselves. It violates no self-incrimination. It violates no self-incrimination. Violates no self-incrimination. To clarify that, however, courts can give permission. However, courts can give permission. Courts can give permission in some cases. Courts can give permission in some cases. Again there, confessions in those tests is not evidence in court. Confessions in those tests. Confessions in those tests is not evidence in court. Confessions in those tests is not an evidence in court. What is it? It is to assist police in their further investigation. It is to assist police in their further investigation. Assist police in their further investigation. Their further investigation. That is your 20 whatever is required for mains aspect. So from the theory part you are writing first. Then we'll write the answers, then some current issues are there, so that everything will add continuously. Then 21, the most important, the most favorite. You only have seen how many times they have touched, they have asked on Article 21. Article 21. Write the statement. No person shall be deprived of. No person shall be deprived of right to life and personal liberty. Deprived of right to life and personal liberty except according to procedure established by law. Except according to procedure established by law. Except according to the procedure established by law. According to the procedure established by law. At that point you clarify there. Of course, the very famous one. Just write PEBL, procedure established by law. PEBL, upheld by Supreme Court in A.K. Gopalan case. PEBL, upheld by Supreme Court in A.K. Gopalan case. Upheld by Supreme Court in A.K. Gopalan case. Sure. Yeah, in simple terms, what does it mean? You can write as a condition. PEBL includes. PEBL, procedure established by law includes. What does it include? A, first one. Is there an act passed by the legislature? Is there an act passed by legislature? Is there an act passed by the legislature? B. Are there detailed rules under the act? Are there detailed rules under the act? You have detailed rules under the act. Are there detailed rules under the act? 3. Did the authorities follow the act and rules? Did the authorities follow the act and the rules? Did the authorities follow the act and the rules? This is what they check in your procedure established by law. Then comes your next one, due process of law. Due process of law. Maneka Gandhi case, 1978. Maneka. Maneka Gandhi case, 1978. Just directly write the equation. Due process of law equals PBL plus due process of law equals procedure established by law plus is the law or rules, is the act or rules, whatever, is the act or rules reasonable, just, non-arbitrary, non-discriminatory. Is the act or rules reasonable, just, non-arbitrary, non-discriminatory? Non-arbitrary, non-discriminatory. Let's say clarify below. Due process of law protects individuals from both. Due process of law protects individuals from both arbitrary legislative and arbitrary executive action. EPL protects individuals from both arbitrary executive and arbitrary legislative action. Means law also can't be arbitrary, execution also can't be arbitrary. From both arbitrary legislative and arbitrary executive action. It's a broader concept. Then, because this anytime, whenever it is in, whenever for your argument's sake, you may have to need it. I showed this kind of your prelims link also 2-3 years back, but you should know about it. Yeah, got to mention there. DPL in essence means principle of natural justice. But principle of natural justice is very important keyword for you in your mains. You have to use it so many times. DPL in essence means, due process of law in essence means principles of natural justice. What does that mean? Clarify there below. What do you mean by the principles of natural justice? Okay, first one. Principles of natural justice. First one, right to be heard. Right to be heard. Right to be heard. That is, every individual has the right to defend himself or herself. Every individual has the right to defend himself, to defend themselves. Every individual has the right to defend themselves. 2. Right to fair trial. Right to fair trial. Accused is considered innocent until proven guilty. Right to fair trial. Accused is considered as innocent until proven guilty. Considered as innocent until proven guilty. 3. Nobody can be judge of his or her own case. Nobody can be judge of his or her own case. Nobody can be judge of his or her own case. Nobody can be judge of his or her own case. Judge of his or her own case. Yeah, then next one. Supreme Court has interpreted Article 21 to include, same again, Menaka Gandhi case. Supreme Court interpreted Article 21. Supreme Court interpreted Article 21 to include anything that is required to live. Anything that is required to live a dignified life. Anything that is required to live a dignified life. Yeah, of course, that's what, this is what is the theory part, which again and again will write in your mains answers. Article 21 is the most broadly interpreted article of Constitution. 21 is the most broadly interpreted article. 21 is the most broadly interpreted article of Constitution. Most broadly interpreted article of Constitution. Third, bracket, invisible amendments. Keywords, invisible amendments. Then first write a list and then right to privacy will write a little detailed one. Give the broader list. Right to privacy case, Puttaswamy case. Right to privacy case, Puttaswamy case. Right to die with dignity. That's again you obviously because the recent Harish Rana case. You have to write it as a little mains angle also for that. Right to die with dignity. Harish, whatever. So which one? What you can write? Originally you can write Aruna Shanbag case. Right to die with dignity, Aruna Shanbag case, or you can write Harish Rana case also. Again, we'll write that in detail now. Harish Rana or Aruna Shanbag. Aruna Shanbag case. Then right to gender identity, Navteej Singh Johar case. Right to gender identity, Navteej Singh Johar case. Navteej Singh Johar case. Navteej Singh Johar case. Right to clean environment, MC Mehta case. Right to clean environment, MC Mehta. Right to clean environment, MC Mehta. Right to education, Unni Krishnan versus State of Andhra Pradesh. Right to education, Unni Krishnan versus State of Andhra Pradesh. Unni Krishnan versus State of Andhra Pradesh. Right against custodial torture and death, TK Basu guidelines or TK Basu case. Right against custodial torture and death, TK Basu case. TK Basu case. Right to speedy trial, Husainara cartoon case. Right to speedy trial, Husainara cartoon case. We call the PIL one. Husainara cartoon case. Husainara cartoon case. Yeah, of course, it's a more broader one. That's different. So now, specifically about which one, a little more details are required under that first one. Right to privacy. Right to privacy. Right to privacy. There, Ambedkar had argued important points and then we'll write the answer separately. Ambedkar had argued that it should be a fundamental right. Ambedkar had argued in the Constituent Assembly. Ambedkar had argued in Constituent Assembly that it should be a fundamental right. It should be a fundamental right. Then Karak Singh case, K-H-A-R-A-K, Karak Singh case. It is not a fundamental right. Supreme Court said that it is not a fundamental right. Karak Singh case, it is not a fundamental right. Then of course, case Puttaswamy case, it is a fundamental right. KS Puttaswamy case, it is a fundamental right under Article 21. It is a fundamental right under Article 21. Within that you can say it includes physical autonomy, decisional autonomy, informational autonomy. Means physical means right to be left alone, bodily autonomy, all of them. Physical autonomy, decisional autonomy. You can take decisions with respect to your life. Decisional autonomy, informational autonomy. Informational autonomy. That is broadly, specifically what does it include? Informational autonomy. Below that, specifically it includes, means if you go to little detailed one, based on that, based on your autonomies, specifically it includes, again of course as a list you write A, right to bodily autonomy, right to bodily autonomy, right to bodily autonomy. Then reproductive rights of women, reproductive rights of women, reproductive rights of women. then right to choice, right to choice, right to choice, then personality rights. That again is a little mains topic continuously in news. We'll write a little detail about it also. Right to personality rights, then right to be forgotten, right to be forgotten, right to be forgotten. So these are broader ones. Of course, 1 or 2 lines you have to write about them. In answers again we'll write that. Then triple test introduced. Triple test introduced by Supreme Court. Same. Yes, Pudaswamy. Triple test introduced by Supreme Court. Now, what do you mean by that? Simple. 3 criteria to be fulfilled by the government. 3 criteria to be fulfilled. 3 criteria to be fulfilled by government. To be fulfilled by government to compromise privacy of individuals. To be fulfilled by government to compromise privacy of individuals. To compromise the privacy of individuals. First one, legitimacy. Legitimacy. Its importance, what does it mean? That is permission of legislature. Is there an act? Legitimacy. That is permission of legislature. Permission of legislature. B. Necessity or legitimate aim. People call first one as legality also. Necessity or legitimate aim means what is the goal? Necessity or legitimate aim. That is purpose of the state. Why are you trying to compromise the privacy? Purpose, goal, purpose of the state. 3. Proportionality. Proportionality. It's important what it means. There should be direct relationship between. There should be direct relationship between. There should be direct relationship between information collected, private information collected of an individual. Direct relationship between the information collected and the goal which is to be achieved. Goal which is to be achieved. Goal which is to be achieved. The landmark one, what is it? Aadhaar Act 2016 was declared constitutional. Aadhaar was declared constitutional. Aadhaar Act 2016 was declared constitutional as it passed, because this is the first major judgment after Pudaswamy. As it passed triple test criteria. Aadhaar was declared as constitutional as it passed triple test criteria. As it passed triple test criteria. If you want other one, electoral bonds was declared unconstitutional. PUCL case. Electoral bonds was declared unconstitutional as it failed triple test criteria. They applied whatever, so many tests were there. That's not very important now. Electoral bonds. Electoral bonds declared unconstitutional. PUCL case as it failed triple test criteria. As it failed triple test criteria. Failed triple test criteria. Then Justice Sri Krishna Committee drafted Data Protection Bill. Justice Sri Krishna Committee drafted Data Protection Bill. Data Protection Bill. Parliament passed it as. Justice Sri Krishna Committee drafted Data Protection Bill. Parliament passed it as Digital Personal Data Protection Act. Parliament passed it as Digital Personal Data Protection Act 2023. Digital Personal Data Protection Act 2023. Data Protection Act 2023. Yeah, that's a factual aspect also. Even that, if possible, we'll discuss that. Because of the detailed provisions of the Act. Digital Personal Data Protection Act 2023. Fine. Now related to 20, okay, that we'll take it as a current affairs angle, which on both because of the right to die with dignity, that is one angle, and the personality rights. If you recall, because of the recent so many issues related to personality rights, Arjit Singh case was there, which one? Abhishek Bachchan case was there, so many cases were there related to personality rights. That maybe if in case doesn't look like a very important issue, but let's write it about it. And then because of the Harish Rana issue, right to die with dignity is in use. Few points about that also we can write it. So as a mains topic. Sure, but we'll first finish off the theory angle and some PYQs, and then we'll come back to that current issues later. Yeah, that is the important ones that you have to remember under Article 21. Then the transgender issues are there. Again, that will write it under same-sex marriage, transgender together will write. That's also as a kind of a mains issue. 21 is still pending. We'll come back to it later again. Then 22, 23, 24, all of that is not necessary so much. Preventive detention, on another way will be controversial. 30, especially directly go to 30 because 30 one or other way will always be in news. Article 30, educational rights of minorities. So because once they are already asked a mains question, let it be there, especially for mains angle. Educational rights of minorities. Educational rights of minorities. Clarify what does it mean? Minorities have the right to. Minorities have the right to establish and administer. And the doctrine of essentiality is there. Okay, I forgot that. That also will write. Minorities have the rights to establish and administer educational institutions on their own. Establish and administer educational institutions on their own. And below that, 44th Amendment 1978. 44th Amendment 1978. Mandatory compensation should be provided. Mandatory compensation should be provided if property belonging to minority institutions is minority institutions is acquired by the state. The property belonging to minority institutions is acquired by the state. Then Constitution recognizes only religious and linguistic minorities. Constitution recognizes only religious and linguistic minority, but there is no definition or criteria. Constitution recognizes only religious and linguistic minorities, but there is no definition or criteria. There is no definition or criteria. Just lastly, because mains points, whatever, clarify there. Religious minorities are based on population of the community across the country. Religious minority is based on population of the community across the country. That's what governments have followed largely. Population of the community across the country. Simple example, Government of India has declared Muslims, Christians, Buddhists, Jain, Sikhs, Parsis. Muslims, Christians, Buddhists, Jain, Sikh, Parsi as religious minority. Then linguistic minorities is based on state level population. Religious linguistic minorities are based on state level population. Linguistic minorities are based on state level population. Simple example, Tulu Konkani speaking people are linguistic minorities in Karnataka. Tulu Konkani speaking people are linguistic minorities in Karnataka. Tulu Konkani speaking people are linguistic minorities in Karnataka. Right now, Supreme Court cases, major ones, which if in case any time the question comes, obviously you should mention about it. Then there's some other current issues, everything, reservation, SC classification, everything, we come back to it. The landmark one, PMA Pi Foundation versus State of Karnataka. PMA Pi, you recall Manipal case. PMA Pi Foundation versus State of Karnataka, 11 judge bench. PMA Pi Foundation versus State of Karnataka, 11 judge bench. 11 judge bench. Yeah, clarify what did Supreme Court say? Article 30 is not absolute. Article 30 is not absolute. State can regulate such institutions, minority institutions. Article 30 is not absolute. State can regulate MEI, minority educational institutions. 30 is not absolute. State can regulate minority educational institutions. State can regulate minority educational institutions. But simple, tell what does it mean? State can prescribe. State can prescribe syllabus, curriculum. State can prescribe syllabus, students admission, teachers qualification, students admission, teachers qualification, examination, teachers qualification, examination, etc. What they can do? Institutions can manage. Institution can manage their property. Institutions can manage their property. Appoint board of directors. Institutions can manage their property. Appoint board of directors. Appoint board of directors and take care of day-to-day management. Take care of day-to-day management. Take care of day-to-day activities. Day-to-day management. This is the landmark one. If on the other one, clarify there below. St. Stephen's College case. St. Stephen's College case. St. Stephen's College case. Up to 50% of the seats. Maximum up to 50% of the seats can be reserved for their own community. Up to 50% of the seats can be reserved for their own community. Can be reserved for their own community. Then Aziz Basha case. AZEEZ. Aziz Basha case. AMU, Aligarh Muslim University, is not MEI, Minority Educational Institution. AMU is not an MEI, Minority Educational Institution. Of course, now it's all reversed, that's a different issue. AMU specifically now it's not in use. That's the content that should be there, at least with respect to Article 30. Then 31, 32 doesn't matter. 31 capital B especially. Reads everything, I think that you can relate. Especially 31 capital B, then 9th schedule. That you should remember from your mains angle. 31 capital B, 9th schedule, added by First Amendment 1951. 9th schedule, added by First Constitutional Amendment 1951. It says that any law related to any subject, passed by Parliament or state legislature, any law related to any subject passed by the Parliament or state legislature, cannot be questioned by judiciary. No judicial review, cannot be questioned by judiciary, even if it violates any fundamental rights. Cannot be questioned by judiciary, even if it violates any fundamental rights, if the act is added to 9th schedule. Cannot be questioned by judiciary, even if it violates any fundamental rights, if the act is added to the 9th schedule. The act is added to the 9th schedule. Now there, I.R. Kohlo versus State of Tamil Nadu, 2007. I.R. Kohlo versus State of Tamil Nadu, 2007. Judicial review is part of basic structure. Judicial review is part of basic structure. Even if an act is added to 9th schedule, it can still be questioned by the courts. Even if an act is added to the 9th schedule, it can still be questioned by the courts. Even if an act is added to 9th schedule, it can still be questioned by the courts. However, doctrine of prospective overruling applied. However, if you recall, yesterday also we wrote the doctrine of prospective overruling applied. Doctrine of prospective overruling applied. What does it mean? Only those acts passed after 24th April 1973. Doctrine of prospective overruling applied. Only those acts passed after 24th April 1973 can be subjected to judicial review. Only those acts passed after April 24th, 1973 can be subjected to judicial review. Fine. There below, dual test introduced. Dual test introduced. Yeah, what is that? Yeah, first one. Does the act violate a fundamental right? The act violate a fundamental right. B. Is that fundamental right part of basic structure? Is that fundamental right part of basic structure? If the answer is yes, an act in 9th schedule can be declared as unconstitutional. The answer is yes, act can be declared as unconstitutional. Act can be declared as unconstitutional. Then Supreme Court introduced rights test and essence of rights test in this case. These all purely means topics. Supreme Court introduced rights test and essence of rights test. Wright's test and essence of Wright's test in this case. Essence of Wright's test in this case. Now, what does that mean? In simple terms, tell what does that mean? Wright's test is narrow in scope. Means more specific, narrow in scope. So, what will they check here? Judiciary will check, Supreme Court will check. Supreme Court will check if any act is directly violating a fundamental right or not. Supreme Court will check if any act is directly violating a fundamental right or not. If any act is directly violating a fundamental right or not. If it is, that means if it violates, of course directly what will happen? It will be declared unconstitutional, null and void, doctrine of severability. If it is violating, if it violates whatever, it will be declared as unconstitutional. This is direct. Normally what we discuss the same thing, Wright's test. And now then what happens then? Or you can say essence of Wright's test is more broader in scope. Essence of rights means they will not only check if it is directly violating or not, even if there is no such provision also, they can still be declared unconstitutional. Essence of Wright's test. It is more broader in scope. It is more broader in scope. Even if the act does not directly violate a fundamental right, even if an act does not directly violate, means it doesn't have specific provisions like that. Even if the act does not directly violate a fundamental right, it can still be declared as unconstitutional. It can still be declared as unconstitutional if it violates the core spirit of constitution or fundamental rights. If it violates the core spirit, that's what is essence. If it violates the core spirit or essence of constitution or fundamental rights. If it violates the core spirit or essence of fundamental rights, means there can be no provision directly, but indirectly also they can apply. If it violates the core spirit or essence of constitution or fundamental rights. That's what is more broader in scope. So, which is more broader? Essence of rights is more broader. So, there may not be a direct provision which directly there is no effect to fundamental rights, but they would have made provisions indirectly in such a way that it looks like freedom of speech will be violated or so and so will be violated. That's a more broader in scope. Wright's test is more direct. It has to be there in words, literal. Okay, all the details is not necessary for us, but Wright's test, doctrine, essence of Wright's test, IR Polo case. That is mains angle. Now, because last year, because you had not last year actually, before that, subclassification of SC, continuously it is in news. Even in few states, Telangana has implemented subclassification of SC, Karnataka has introduced it. So, kind of current affairs angles from the last 1 or 2 years, anytime it can be in news. So, that's why considering that, make it more broader, overall related to vision, broadly everything related to reservations, the broader angle, and more specifically with respect to subclassification will write. Reservations. If you just want the first historical angle, if you want, clarify there. Even during British rule, reservations was introduced. In provinces like Madras and princely states like Mysore. Provinces like Madras, princely states like Mysore. I mean, there are so many actually, even in Baroda, Kerala, in Travancore also. Provinces like Madras, princely states like Mysore. Fine, yeah, clarify below. It is based on principles of substantive equality. In other words, equality of outcome. So you have to use those keywords: substantive equality, equality of outcome, affirmative action, principles of substantive equality, equality of outcome, affirmative action, positive discrimination, positive discrimination, positive discrimination, social justice, positive discrimination and social justice. So any of those words, whenever there is a topic related to it, you have to regularly use it. Fine. Then Ambedkar strongly argued in favor of it. Ambedkar strongly argued in favor of it. Ambedkar strongly argued in favor of it to correct the historical injustice. In favor of it to correct the historical injustice. Correct the historical injustice and ensure, provide adequate representation. Ensure adequate representation for backward classes. Adequate representation for backward classes in policy making and public administration, that is governance. Adequate representation of backward classes in policy making and administration. Policy making and administration. Clarify that. Policy making and administration below. Constitutional provisions. Constitutional provisions. Constitutional provisions in favor of reservation. First let's list it and then we'll write the details. Constitutional provisions in favor of reservations. I mean, of course, you know, so many are there. Under that first one, 15 clause 4, 15 clause 5, 15 clause 6. 15 clause 4, 15 clause 5, 15 clause 6. If you have forgotten that, just for your information sake, if you want it, mention that 15 clause 4. Well, what does that mean? Special provisions. Special provisions for SC, ST and OBC. To be precise, SC, BC, socially, educationally backward classes. Special provisions for SC, ST and OBCs. SC, ST and OBCs. 15 clause 5. Special provisions for same SC, ST, OBC with respect to special provisions for SC, ST and OBC with respect to which one? Exactly. Professional educations. With respect to professional education, that is UG, PG, whatever, including private institutions. Including private institutions. 15 clause 6. EWS reservation up to 10% in professional education. 15 clause 6. EWS reservation up to 10%. EWS reservation up to 10% in private institutions, or you can say not private, professional institutions. Professional educational courses. Professional educational institutions. Because you know in bracket, which is 103rd Amendment 2019, Janhit Abhiyan case. 103rd Amendment 2019, Janhit Abhiyan case. Supreme Court upheld it, in other words. Janhit Abhiyan case. In the 15, what all supported? Then 16 clause 4, the landmark article. 16 clause 4. 16 clause 4. State can reserve. State can provide reservations. State can provide reservations in favor of any backward classes. Provide reservations in favor of any backward classes. In favor of any backward classes. So this is where, with respect to public employment. With respect to public employment. with respect to public employment. Then 16 clause 6, 10% EWS reservation in jobs. 16 clause 6, 10% EWS reservation in jobs. 10% EWS reservation in jobs. In fundamental rights, what will support your reservations? Then Article 46, DPSPs. All provisions which support reservations. Article 46. You tell. Exactly. Improve economic, educational opportunities for economic, educational opportunities for any backward class, any backward sections. Educational and economic opportunities for any backward sections. Then Article 335, 335. Reservation should not compromise efficiency or merit of administration. 335. Reservation should not compromise efficiency or merit of administration. Efficiency or merit of administration. We are talking overall reservations, education, employment, even each one, this also you can write. Overall reservation. Then 243D, 243T, 243 capital D, 243 capital T. Of course, 243 means you tell reservations for SC, ST in panchayats, municipalities. Reservations for SC and ST in panchayats and municipalities. Reservations for SC and ST in panchayats and municipalities. 330, 332. 330, 332. Reservations for SC and ST in Lok Sabha and State Assembly. Reservation 330, 332. Reservations for SC and ST in Lok Sabha and State Assembly. Lok Sabha and State Assembly. Then the recent, if you want that also, any overall reservation points, we are just mentioning it. 330 capital, again, women reservation will write separately under Parliament. 330 capital A, 332 capital A. Women reservation in Lok Sabha and Assembly. 330 capital A, 332 capital A. Reservations for women in Lok Sabha and State Assembly. Lok Sabha and State Assembly. Lok Sabha and State Assembly. Fine. These are broader provisions related to reservations. Yeah, now under that, the most important judgment, first which one? Indira Sani case, 1992. And then gradually we'll come to the recent subclassification of SC, that arguments in favor, arguments against, everything. Indira Sani case, 1992. First one, what is it? OBC reservation constitutionally valid. OBC reservation constitutionally valid. Constitutionally valid. 2. Total reservation should not cross 50% except in extraordinary circumstance. Total reservation should not cross 50% except in extraordinary circumstances. Except in extraordinary circumstances. Then, creamy layer within OBC should be excluded. Creamy layer within OBC should be excluded. Creamy layer within OBC should be excluded. Within OBC should be excluded. Then, reservation only in entry stage, appointment stage, not in promotion. Reservation only in appointments level, not in promotion. Only in appointment stage, not in promotion. be in appointment stage, not in the promotion. And then statutory body, all of that is not necessary. And this is the core of your Indrasani ones. And now another which one? Article 16, clause 4A. 16, clause 4A. 77th Amendment 1995. Article 16, clause 4A. Added by 77th Amendment 1995. 7th Amendment 1995. Reservations in promotions for SC and ST. Reservations in promotions for SC and ST. Promotion for SC and ST. Under that, M. Nagraj case. Nagraj case, Supreme Court upheld it. Upheld reservations in promotion. M. Nagraj case, Supreme Court upheld it. But introduced triple test criteria. So this is, that is, Swami is another triple test, this is another triple test. In Nagraj case, Supreme Court upheld it but introduced triple test criteria. What are they? A, first one, inadequate representation of the community. Inadequate representation of the community. Bracket, quantifiable data. To prove it that it is not adequately represented. Quantifiable data. Backwardness of the community. Backwardness of the community. B. Merit or efficiency should not be compromised. Merit or efficiency should not be compromised. Merit or efficiency should not be compromised. Then Jarnail Singh versus Lakshmi Gupta. Jarnail Singh, Jarnail. Jarnail Singh versus Lakshmi Gupta, LACHHMI. Jarnail Singh versus Lakshmi Gupta. Quantifiable data is not necessary. Jarnail Singh versus Lakshmi Gupta. Quantifiable data is not necessary. Consequential seniority. Consequential seniority is legally valid. Consequential seniority is legally valid. Means reservation in promotion will be based on consequential seniority. Again, what is that? Everything, we go back to the basics, would have already discussed it. Consequential seniority is legally valid. Sure. So these are with respect to reservations in promotions. And now comes which one? The recent issue, extension of it, which is which one? Yeah, exactly. Continue that. Subclassification of SC. Subclassification of SC. Yeah, write the overall provisions first. Article 341. Article 341. Constitution empowers President. 341. Constitution empowers President to officially notify. Empowers President to officially notify list of SC. President to officially notify the list of SC. In other words, only who can determine it? Hence, states have no role. States have no role in determining SC. You have forgotten that terminology. States have no role in determining SC, because that point is necessary for you to understand this more. Point, states have no role to determine SC. In case you have forgotten, just mention that. What is 341? place of SC, you can mention ST also. That will become 342. Right? Like clarify mentioned there. Parliament has to amend constitutional order SC list. Parliament has to amend constitutional order SC list. SC has to be in bracket. Constitutional order SC list by simple majority. Parliament has to amend constitutional order SC list by simple majority. That's the procedure angle in general to determine SC, because based on that only subclassification will happen. So exact same provision will apply to ST with respect to which article? 342. Similar provision applies to ST under 342. Similar provision, exactly same. President will notify list of ST under 342. Similar provision applies with respect to ST under 342. Applies with respect to ST under 342. Now, what is the subclassification angle? First mention EV Chinnaya versus state of Andhra Pradesh. EV Chinnaya versus state of Andhra Pradesh. EV Chinnaya versus state of Andhra Pradesh. SC is a homogeneous category. SC is a homogeneous category, hence subclassification is not allowed. Hence subclassification is not allowed. Subclassification, homogeneous is the keyword. Hence subclassification is not allowed. Then recent Davinder Singh versus state of Punjab. Davinder Singh, Davinver. Davinder Singh versus state of Punjab. 7-judge bench. Davinder Singh versus state of Punjab. 7-judge bench. 7-judge bench. SC is a heterogeneous category. SC is a heterogeneous category. Hence, subclassification is legally valid. Hence, subclassification is legally valid. Subclassification is legally valid. Subclassification is legally valid. Who can subclassify it? Respective states can subclassify it for the purpose of state government jobs. Respective states can classify it. Respective states can subclassify it. Respective states can subclassify it. And which is the first state? Telangana is the first state, followed by Karnataka. My MP or also someone also did it. Telangana is the first state, followed by Karnataka. That is what do you mean by sub. Now comes here the main angle mentioned there below. Arguments in favor of subclassification. Why do you need it? Very simple logic you can easily apply. Arguments in favor of subclassification. Arguments in favor of subclassification. Yeah, first one is obviously what? SC is a heterogeneous category. SC is heterogeneous category. Heterogeneous category. In other words, what does it mean? Few sections or few sub-communities or whatever. Few sections are very backward. Few sections are very backward. Hence deserve better opportunities. Few sections are very forward, very backward. Hence deserve better opportunities. Hence better opportunities. Hence better opportunities. 2. Promotes substantive equality. Equality of outcome. Promotes substantive equality and equality of outcome. substantive equality and equality of outcome. Substantive equality, equality of outcome. Equality of outcome. Then next one, real benefits will reach the last person. Real benefits will reach the last person. Real benefits will reach the last person. Right, then subclassification within OBC. Subclassification within OBC is successfully implemented across many states. Subclassification of OBC is successfully implemented across many states. Successfully implemented across many states. Example, Bihar, most famously, Karnataka, Maharashtra. It's the same model, why can't you apply here is the logic. Example, Bihar, Karnataka, Maharashtra. Across many states. And then Supreme Court has empowered respective states to consider local criteria and subclassify SC. It means it's not a uniform one, respective states can do it on their own. Supreme Court has empowered respective states to consider local criteria or local, reality. Has empowered states to consider local reality and subclassify SC. And subclassify SC. So then obviously always what you will have, challenges or arguments against. Arguments against. Of course, very simple logical ones. Arguments against. Of course, first logical argument is what? It will. Arguments against. It will divide the community. It will divide the community, affecting their unity, cohesion. Divide the community, affecting their cohesion or unity, affecting their unity and cohesion. Chances of politicization is very high. 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 Of course, then major challenge is which one? Criterias. Criterias are not clearly specified by Supreme Court. On what basis will you do it? Criterias are not clearly specified by Supreme Court, hence chances of misuse. Criterias are not specifically mentioned, clarified by Supreme Court, hence chances of misuse is high. Chances of misuse is high. Chances of misuse is high. Then of course what they lack? Most of the states lack. Most of the states lack. Most of the states lack objective data. Most of the states lack objective data. Most of the states lack the objective data to determine backwardness. Lack objective data to determine backwardness. To determine backwardness. Yeah. Then how do you address it then? Way forward. Way forward. Cast census and surveys. Cast census and surveys with specific criterias. With specific criterias like Bihar, Karnataka. Bihar and Karnataka. Specific criterias like Bihar and Karnataka. That is the first one. Then two. Second one, politicization. Politicization should be avoided. Politicization should be avoided. For this, what can help? People's awareness, judicial checks and balances, can help in this. People's awareness and judicial checks and balances can help in this. Judicial checks and balances can help in this. Judicial checks and balances can help in this. Okay. Right, so that is your recent subclassification of SC angle. Then there was another issue, but which is not, I don't think that's a mains angle, you will not get in that. If you recall that religious converts, if you recall Supreme Court, I think last month itself that given a judgment, if you recall, Chintada Anand Paul case, where if you have converted from SC to another religion, you cannot ask for protection again under SC/ST Atrocities Act, all of that, but I don't think that's a kind of a mains angle. That's not necessary to write there. If you want, just as a what do you call this fact, maybe in your essay or ethics, just mention that somewhere in the margin, not as a typical mains topic, just as a fact. Chintada Anand Paul case. Chintada, Chintada, Chintada Anand Paul case. Chintada Anand Paul case. Supreme Court said that if a person has converted from SC to other religion, protection cannot be demanded under SC/ST Prevention of Atrocities Act. Protection cannot be demanded under SC/ST Prevention of Atrocities Act. Protection cannot be demanded under SC/ST Prevention of Atrocities Act. Prevention of Atrocities Act. But clarify there itself. Supreme Court also clarified that ST is religion neutral. ST is religion neutral. Means which religion doesn't matter to people belonging to scheduled tribe, religion neutral. In other words, what does that mean? That is, STs of any religion are eligible for reservation. STs of any religion are eligible for reservation. Because if you recall, if you are SC and get converted to Christianity or Islam, you will not get reservation. STs of any religion are eligible for reservation. For a clarity, however, SCs of only Hinduism, Buddhism, Sikhism are eligible for reservation. SCs of only Hinduism, Buddhism, Sikhism are eligible for reservation. In other words, Christians, Muslims, SCs of Christians and Muslims are not eligible. SCs of Hinduism, Buddhism, Jainism are eligible for reservation. SCs of Christianity, Christians and Muslims are not eligible. This will not become a mains question, don't worry, because it's very, very sensitive. But because it was there in news, I just mentioned it. Fine, that is overall topic related to the reservations, including the recent subclassification of SCs, the constitution provisions, everything. And as I told, personality rights is there, which is also a mains topic, which is kind of in news. Harish Rana case, the passive euthanasia or right to David dignity is there. It's also a kind of mains issue. But before that, what we'll do, we'll try to write answers for some PVQs. Then we'll come back to your current issues. Morality, we'll come to this right to privacy. The recent ones that we mentioned today. Look at this, 2024, 2023. Justice, then environmental, then okay, this is more easy. We did not write that. These are the recent issues. 24 question is this. Look at it. Before that, what we'll do, we'll go one by one so that it will be more easy for you. First, let's write this. I mean, note down the question. 23. 25, they did not ask a question on fundamental rights. 24, 1, 23, 2 question. 22, 2 questions. And then 21, 20, no questions. Right? Yeah, if you look at the wordings itself, you will easily understand. Clearly telling you, Constitution is a living instrument, enormous dynamism, so which is made for a overall. They are talking about doctrine of living tree aspect that you substantiate to a little extent, maybe with doctrine of living tree aspect, blend of registry flexibility, as whatever we wrote constitutional amendment angle. Right, the most important constitutional amendment in some 4-5 you establish and say, see, constitution is continuously evolving, it's more dynamic to adjust to a progressive society. Then larger part of the question you have to deal with which one, because they are clearly telling you illustrate also, means whenever you say illustrate here, take it as what? Specific, normally case laws. Illustrate, and then they are telling you specifically with respect to which one? Article 21. So that part, then what you have to understand, I explain there, because you should not write only and only with respect to right to privacy here, because they are not telling you right to privacy. What are they telling? Right to life and personal liberty. So overall Article 21. Then what you have to tell, how Supreme Court has broadly expanded is one angle. Then what you have to tell, what are the challenges if Supreme Court expands it so broadly? Because it's easy for Supreme Court to expand it, but what challenges will it create in reality with when they give such a broader scope for Article 21? And then if in case you can mention some other way forwards or conclusion aspect, all of that you have to cover. Normally what happens, what we'll do, we'll address this. Sometimes students will not even address that first statement. Remember, whatever words they have mentioned in question, even if they put it as a broader statement or anything, so many times you might have seen one statement they'll put, and then they'll say something. Yesterday as we wrote constitutional morality, some statement they'll tell, and then they'll continue. So that statement is not just given there. Of course, it is setting a context. That's not the core demand, but you have to address that statement also first. Though not in detail like one page, at least 1 or 2 pairs. Why is that statement given? What is that word called as living instrument? What do you call it as enormous dynamism? What do you call it as progress? Address those words also. Also, or else evaluator will feel you are not even mentioning about it directly. You are going to right to life and personal liberty. Means you are not even giving importance to that first aspect. It's not a subheading. It's not a subpart. Yes, we are not saying write complete 1 or 2 subparts on it. Agreed. You don't have to do that. At least 1 or 2 paragraphs you have to address. What does that mean? Then come to the core demand. Is that clear? Yeah. Okay. So based on that, first address those issues. Let's start with that. Write the answer. I'll only tell you. After you write 1 or 2 answers, I'll make you, we'll keep a timer, and then so that you can write 1 or 2 specific answer. First, let's start with address that aspect. Constitution is a living instrument. That yesterday what you wrote, continue with that. We have already written the theory part. Indian Constitution is based on doctrine of living tree. Indian Constitution is based on doctrine of living tree. It is an organic, dynamic document. It is an organic, dynamic, or living, whatever words, but we are using the word which is mentioned in the question. Organic, dynamic document which continuously evolves and adapts. According to the changing needs and circumstances. Which continuously evolves and adapts according to the changing needs and circumstances. According to the changing needs and circumstances. So clarify there. Constitution has established, has provided, Constitution has provided blend of rigidity and flexibility. Constitution has provided a blend of rigidity and flexibility. Article 368. Empowers Parliament to amend Constitution. Empowers Parliament to amend Constitution to promote a progressive society. Parliament to amend Constitution to promote progressive society. Promote a progressive society. Then below that, just clarify there. Important or significant constitutional amendments include. First, below that, 7th Constitutional Amendment 1956. States reorganization. 7th Constitutional Amendment 1976. States reorganization. 44th Amendment 1978. 44th Amendment 1978. Right to property. Right to property made a constitutional right. Right to property, so many issues were there. Right to property made constitutional rights. 52nd Amendment 1985. Anti-defection law. 52nd Amendment 1985. Anti-defection law. 73rd, 74th Amendment 1992 to promote decentralization. Panchayat municipalities. 73rd, 74th Amendment to promote decentralization. 101st Amendment 2016 GS-2. 101st Amendment 2016 GS-2. 106th Amendment 2023 Women's Reservation. 6th Amendment 2023 Women's Reservation. That's just the first, that double inverted, whatever you have, we are trying to address that. Yeah, that's why what is it? Hence, Indian Constitution is a transformative document. Hence, Indian Constitution is a transformative document. Transformative document. Indian Constitution is a transformative document. Now, in that context below, now let's you have to go to that, because expanding horizons, this is, clarify there. Constitution empowers Supreme Court to interpret the Constitution empowers Supreme Court to interpret the Constitution and the laws. powers Supreme Court to interpret the Constitution and the laws. And of course, what is it called as? It is considered as the ultimate interpreter of Constitution. We are using the linking paragraph, then we'll go to the main part. It is considered as the ultimate interpreter of Constitution. Ultimate interpreter of Constitution. What it has done? It has introduced various invisible amendments to the Constitution. It has introduced various invisible amendments to Constitution. Various invisible amendments to Constitution, which is the most broadly expanded. Article 21 is the most broadly expanded article. Article 21 is the most broadly expanded article, especially post Maneka Gandhi case. 21 is the most broadly expanded article, especially post Maneka Gandhi case 1978. Post Maneka Gandhi case 1978. All of those ultimate interpreter, invisible amendments, Maneka Gandhi case, keywords, keep on underlining it. Please don't miss out on those aspects. And now put the small subheading, which one? Keyword, same keyword use, expanding horizons of right to life and personal liberty. Put that subheading. That you have to write that list. Expanding horizons of right to life and personal liberty. Expanding horizons of right to life and personal liberty. Right to life and personal liberty. Yeah, under that first one. Maneka Gandhi case. Article 21 includes anything to live a dignified life. Maneka Gandhi case. 21 includes anything to live dignified life. Dignified life is the keyword. Anything to live a dignified life. MC Mehta case. Right to clean environment. Whatever you wrote that list. Right to clean environment. Right to clean environment. Of course, to protect what? To protect individuals. Protect individuals. Protect individuals from. Protect individuals from polluted air, water, or to get access to it positively if you want. Protect individuals from polluted air, water, etc. Then right to privacy. Swami case. Right to privacy. Swami case. Itself includes. As we wrote, right to bodily autonomy, reproductive rights of women, etc. Right to bodily autonomy, reproductive rights of women, etc. Reproductive rights of women, etc. Right then, right to die with dignity. Right to die with dignity. Right to die with dignity. Aruna Shanbag case. Right to die with dignity. Aruna Shanbag case. Simple terms, what does that mean? To allow people under permanent vegetative state. Aruna Shanbag case. To allow people under permanent vegetative state. People under permanent vegetative state to die with dignity. People under permanent vegetative state to die with dignity. Vegetative state to die with dignity. Then, right to gender identity. Right to gender identity. Navteet Singh Johar case. right to gender identity, Navteej Singh Johar case. Section 377 of IPC, which Section 377 of IPC, which criminalized homosexuality, was declared unconstitutional. Section 377 of IPC, which criminalized homosexuality, was declared unconstitutional. Criminalized homosexuality was declared unconstitutional. Declared unconstitutional. That is the expanding horizons. Now, because of it, what it has done, that's your linking sentence. Then we have to go to the criticism. Due to such broad interpretation, or use the same word, due to expanding horizons of Article 21, due to expanding horizons, due to expanding horizons of Article 21, expanding horizons of Article 21, rights of vulnerable sections are upheld. Rights of vulnerable sections are upheld. Rights of vulnerable sections are upheld. Supreme Court has fulfilled its role as Supreme Court has fulfilled its role as guarantor of fundamental rights. Supreme Court has fulfilled its role as guarantor of fundamental rights. Now come to the next part. However, it has created multiple challenges. It has created multiple challenges and complexities. It has created multiple challenges and complexities. Multiple challenges and complexities. Now, what are they? First one, resource constraint. Resource constraint. Simple as what does it mean? Governments do not have, explain that point, resource constraint. Governments do not have adequate resources. Governments do not have adequate resources. Governments do not have adequate resources to implement all the components of Article 21. Because you have to give education, healthcare, everything. Where is the adequate resources to fulfill all the components of Article 20? If you want simple example, for example, right to healthcare is part of 21. Right to healthcare is part of 21, but practically remains a paper tiger. Paper rights. Right to healthcare is part of 21, but practically remains a paper right. Paper right means theoretically it's there. Practically you don't have any act, nothing. Practically remains a paper right. Paper right is a keyword. Means theoretically there, practically there are no resources. How will you ensure it? Assured. 2. Second one is which one? Legal complications. Legal complications. For example, right to privacy versus right to information. Right to privacy versus right to information. Right to privacy versus right to information. Right to clean environment versus development, livelihood issues. Right to clean environment versus development, livelihood issues. How do you balance all of them if you keep on extending everything? Short. Then even there itself, if you want, okay, another point, if you want, you can make it as practically difficult for government to implement. Practically difficult for government to implement caste census. Implement caste census. due to privacy concerns. Caste census to implement privacy concerns. Example, Bihar caste census. Practically difficult to implement caste census or caste surveys due to privacy concerns. Example, Bihar government could not implement caste survey, caste census, as Patna High Court opposed it in the beginning. Later they allowed it, that's a different issue. Bihar government could not implement caste census as Patna High Court opposed it in the beginning. Patna High Court opposed it in the beginning. Then obviously another one is which one? Security concerns. Security concerns. Law enforcement agencies cannot intercept communications due to, again same, privacy, right to privacy. Like that, so even LGBTQ issues are also there. These are all the concerns or challenges that will, okay, another one, the broader one, which is what? It leads to, or it has led to, means broader expansion, expanding horizon has led to, it has led to, which is very favorite, always you will keep writing that. It has led to judicial overreach and what? Supremacy. Led to judicial overreach and supremacy. Judicial overreach and supremacy. Yeah, that is the criticisms one. But obviously what you have to tell, whatever said and done, so Supreme Court has to have this kind of one because it has helped a lot. Rights-based approach, everything is ensured. That overall sum up everything. Supreme Court's broader interpretation of Article 21. Supreme Court's broader interpretation of Article 21. Broader interpretation of Article 21 has ensured rights-based approach to development. Broader interpretation of Article 21 has ensured rights-based approach, because everything is the right, health is the right, education is the right, environment is the right, has ensured rights-based approach to development necessary for a dignified life. Necessary for a dignified life. But what Supreme Court should also keep it in mind, however, Supreme Court should also consider legislative, administrative constraints. Should also consider legislative, administrative constraints, and ensure a fair balance between multiple rights. Ensure a fair balance between multiple rights, so that it does not create unnecessary legal complications. Broadly, this is one way. Of course, you can search, there would have so many informations, you will get so many different ways of writing are there. Just go through it once. So broadly, how you could have structured this particular question. This is 23's question. Now, if you have this content, DNA testing is a little different one, but the other question you can write it. justice also you have to write now. Environmental problems also you have to write. I think this is more easy. You can only write it. There is nothing extraordinary. Okay, will not write that because that's easy for you to write. This one will first gender justice also will write. These two will write. This you have to write it. See, same way. Examine the scope of fundamental rights in the light of latest judgment on right to privacy. So, what should be the structure then? They are telling you examine the scope. So, means in other words, what they are trying to say is that now that because Supreme Court has introduced or considered right to privacy as what? Part of fundamental right under Article 21, how will it expand the scope of Article 21 or right to privacy? Obviously means what, as I told, because this will be considered as a fundamental right, what all got added under it? We have mentioned what all is part of right to privacy itself. Bodily autonomy, reproductive rights, right to choice, right to be forgotten, right to personality, all of that will get expanded. Now first what you have to tell, basic in the introduction you have to tell what is this article or what is this in general fundamental rights mentioned in part 3, article 12 to article 35, should famously called as Magna Carta of Indian Constitution, something like that. You have to introduce first, tell basics about what do you mean by this fundamental right. Then they are talking about in the light of latest judgment right. Now first obviously what you have to tell, the Supreme Court is considered as ultimate interpreter of Constitution, guarantor of fundamental rights. Hence what it has done, continuously it has given broader scope to fundamental rights. And then come to the latest, Supreme Court recently considered or recently declared what, right to privacy as a fundamental right in the landmark case, Puttaswamy case. And then due to this, what you have to tell, scope of fundamental rights, of course obviously under specifically which article, under Article 21 will expand. Now expansion, what all does it expand? You have to write that, and 1 or 2 lines you have to write about it. Then what you have to write, now due to this expansion, of course advantages, obviously expansion is there, but what it will also create, if this expands to such an extent, what challenges will it create? Specific, you can't write in general about 21, specifically you have to write about privacy. For example, if reproductive rights of women keeps on expanding, the next issue which what will come? Obviously which one? Right to abortion issue will come, which will create so much of cultural, religious, legal complications. That challenges will come. Of course then what? Right to be forgotten will come. Then how will you implement it in the era of whatever, AI era, digital era, everything, how will you implement that? Positives are also there. Again, challenges also you have to write that. Then same way, when they include right to choice and everything. Now the issue of what? Same-sex marriage is, we obviously discuss it under Supreme Court, that also. The Supreme Court has not agreed it yet. That challenges it will create again in future. Then obviously right to bodily autonomy is there. In that context, what gets difficult? Obviously, what do you call this? If you want to collect some Aadhaar data also it gets difficult, or if you want to, what do you call this, the DNA testing of whatever womb, I mean of the child in the womb, even that gets difficult because it's a kind of privacy for the mother, it's a kind of privacy for the child, so many issues will come. So all of those challenges will come. Plus of course as I told, security issues. Like if you want everything, if you tell it as privacy, how will government, how will police work, how will law enforcement work, any information if you try to do, legal complications are there, right to information. So people want to know about so many things, but politicians or leaders might tell it is privacy. So all these, how will you manage? That's the challenges angle also you have to tell. Now for that solution, DPDP, digital personal data, don't consider it, you need not consider it as 2017 question. Take it as what? If this year same as question if they ask, what should be your answer? That broadly you have to include everything. Good. Looks like a little more specific one, so that's why we'll only write it first, and then we'll go back to again your constitutional, gender justice and environmental questions again. Then we'll write the DNA testing. Fine, okay, copy the question. I thought I'll make you write this, but looks like a more broader question. Examine the scope of fundamental rights in the light of latest judgment on right to privacy. Take some 10 minutes break and come back. We'll write the answers. You guys have noted down the question, right? Okay. So please write the answer for this. Let's write it. Continue to focus on the structuring part, how multiple dimensions have to be addressed. Question broadly is on fundamental rights. Start with that. Fundamental rights is famously called as Magna Carta of Indian Constitution. Fundamental rights is famously called as Magna Carta of Indian Constitution. Magna Carta of Indian Constitution. It is mentioned in Part 3. Magna Carta of Indian Constitution. It is mentioned in Part 3, Article 12 to Article 35. Part 3, Article 12 to Article 35. Article 12 to Article 35. So because you can't define anything here, so we are making it as a broader one. Some people, what they do, if it's a 15 marker, what they try to do, below that, what are the major fundamental rights, like a list of fundamental rights in Constitution, or some people tell significance of fundamental rights. But the question is not about significance or anything here. That's why we need not mention specifically about it. Directly, let's go to the scope. Yeah, let's get to the scope first. Before that, first tell how Supreme Court can expand that scope. Clarify that below. Constitution has mentioned 6 broad fundamental rights, like, we're not mentioning everything, just linking to that. It's like a linking paragraph. Constitution has mentioned 6 broad fundamental rights, like right to equality, right to freedom, etc. Right to equality, right to freedom, etc. But who has continuously given greater scope? Right to equality, right to freedom, etc. Supreme Court has consistently expanded. Supreme Court has consistently expanded the scope of fundamental rights. Consistently expanded the scope of fundamental rights as it is the ultimate interpreter of the Constitution and guarantor of fundamental rights. As it is the ultimate interpreter of Constitution and guarantor of fundamental rights. Ultimate interpreter of the Constitution and guarantor of fundamental rights. That's the context. Now get to this. I have to put that case itself if you want. Right to privacy. Right to privacy. Supreme Court declared right to privacy as a fundamental right under Article 21. Supreme Court has declared right to privacy as a fundamental right under Article 21 in the landmark case, Puttaswamy case. Right to privacy as a fundamental right under Article 21 in the landmark KS Puttaswamy case. The landmark KS Puttaswamy case. And of course, what this has done, now get to that. This has expanded the scope of fundamental rights, especially Article 21. This has expanded scope of fundamental rights, especially Article 21. I clarify that. At present, it includes, especially right to privacy angle. At present, right to privacy includes. Present right to privacy includes. As a list, multiple times by now we have mentioned. First one, right to bodily autonomy. Right to bodily autonomy. Right to bodily autonomy. 2. Reproductive rights of women. Reproductive rights of women. Reproductive rights of women. 3. Rights to choice. Right to choice. It can be with respect to marriage, it can be food. Right to choice with respect to marriage, food choices, whatever, lifestyle choices, everything. Right to choice, which includes marriage, food choices, lifestyle choices, etc. Rest everything is part of that. Then, right to be forgotten. Right to be forgotten. Simple terms, tell what does that mean? Right to be forgotten, that is, right to be forgotten, that is, information related to an individual. Information related to an individual which is not necessary in the larger public interest. Information related to an individual which is not necessary in the larger public interest. Not necessary in larger public interest can be erased from the digital domain. Is not necessary in the larger public interest can be erased in digital, erased from whatever digital domains. In other words, whatever websites, internets, erased from the digital domain. Right to be forgotten. Then personality rights of an individual. Right to personality. Right to personality. Right to person. That itself is a means topic again. We'll write that separately. Right to personality. I tell what does that mean? Just simple words. The details we can't write here. Right to personality. Tell. It prevents unauthorized use of. Prevents the unauthorized use of the name, unauthorized use of the name, image, voice, mannerisms of an individual, especially celebrities, but everybody included. Unauthorized use of the name, signature, voice, mannerisms of individuals, especially celebrities. Especially celebrities. Yeah. Recently where? Recently upheld in. Recently upheld in. Recently upheld in. Whatever, so many cases were there. Amitabh Bachchan case, upheld in Amitabh Bachchan case, Arijit Singh case. That again specifically will write. Upheld in Amitabh Bachchan case, Arijit Singh case. This has obviously broader expansion. Now, due to this, what will happen? Obviously, reproductive rights, everything we have mentioned. Fine. So, specifically, if you mention that due to this, that is due to Supreme Court judgment, due to this, Parliament passed Personal Digital Data Protection Act. Digital Personal Data Protection Act 2023. Due to this, Parliament passed Digital Personal Data Protection Act 2023 based on Justice Sri Krishna report recommendations. Based on Justice Sri Krishna report. And if you want to mention it another bigger kind of a scope angle or the significance angle, mention right to privacy. Right to privacy is in tune with, is in harmony with, right to privacy is in tune with international conventions. Right to privacy is in tune with international conventions. UNDP, but not UNDP, UDHR, international conventions, UDHR, ICCPR, etc. Use, remember, digital data protection regime, general data protection regime, GDPR. Fine, UDHR, Universal Declaration of Human Rights, ICCPR, EU's, European Union's, GDPR, General Data Protection Regime, European Union's GDPR, now this is not so much in use, but it's a very famous one. General Data Protection Regime. Good. And of course, who had also strongly argued? Ambedkar angle, will write it at the end. Yeah, this is international angle one. Now, what are the, examine the scope, right? As I told, whatever it can be the directives, explain the challenges if you have that part, whatever I have told you, clarify that, continue. Such a broader expansion of right to privacy, such a broad expansion of right to privacy has created multiple administrative legal challenges. Such a broad expansion of Article 21 or right to privacy, whatever, right to privacy has created multiple legal administrative challenges. Multiple legal administrative challenges. Multiple legal and administrative challenges. Fine. What are those challenges? You can't write about right to environment, everything here. Specifically, you have to write only which one? Right to privacy related challenges. I've already 2-3 I've already told you. Clarify that. First one, right to privacy versus right to information. Right to privacy versus right to information. Right to privacy versus right to information. Fine. Then right to privacy versus security related challenges, especially for law enforcement agencies. Right to privacy versus security related concerns, especially for law enforcement agencies. That's why if you recall your rules, digital data protection rules, everything makes lots of exception. Again, that also we'll discuss separately. That's a typical current affairs angle. Right to privacy versus security related concerns, especially for law enforcement agencies. For law enforcement agencies. Right. Third one, reproductive rights of women. Reproductive rights of women. Reproductive rights of women has raised the demand for. Reproductive rights of women has raised the demand for. Right to abortion. Raise the demand for right to abortion, which will create, or which has right to abortion, which has cultural, religious, moral dilemmas. Which has cultural, religious, moral dilemmas. Cultural, religious, moral dilemmas. Right, that's another angle. Then, right to choice. Right to choice, marry, has raised the demand for same-sex marriage. Right to choice and marriage or marry has raised the demands for same-sex marriage. Same-sex marriage to be legally valid under Special Marriage Act, which of course Supreme Court has not accepted it. Raise the demand for same-sex marriage to be legally valid under, say, Special Marriage Act 1956. Special Marriage Act 1956. This is a demand. If you want in bracket, you write. However, Supreme Court did not accept it under Suprio case. However, Supreme Court did not accept it under Suprio case. Supreme Court did not accept it under Suprio case. Then, administrative challenges with respect to policies, welfare schemes. Administrative challenges with respect to policies and welfare schemes as caste surveys, demographic information, caste surveys, demographic information also raises privacy concerns. As I told, Patna, Bihar caste census issue. Caste census, demographic data also raise privacy concern. Example, Bihar caste census legal complications. Bihar caste census legal complications. caste census legal complication. Yeah. So in that context, what does the Supreme Court do? Clarify that. First, tell it in a positive note itself. Supreme Court has Supreme Court has transformed the nature of Article 21. Say expanded also positively. Transform the nature of Article 21 by including right to privacy within it. However, it has created legal complications. So many other versus so many other rights. Legal complications. Hence, who should only strike a balance? Supreme Court should strike a balance. Hence, Supreme Court should strike a balance. Supreme Court should strike a balance between multiple fundamental rights. Supreme Court should strike a balance between multiple fundamental rights to fulfill the real goals of the constitution makers. That is dignified life of an individual. Real goal of the constitution makers, that is dignified life of an individual. This is the broader way, examining the scope, how it has positively expanded, how it will create a lot of legal challenges. Of course, in the way forward, you can also write Digital Data Protection Act, so that can make a much better balance. Like that, so many things. Fine, please go through it once. Now we'll again write which one. DNA testing one is there, again it will become ready. One is gender justice, another is environment. Gender justice is 23. It's a more broader one. For the demand, okay. Before that, we'll write environment. Please copy this question. Two specific keywords. When you read the question, especially when you're writing means, please encircle those keywords so that whenever throughout your answer, it should be there in your mind. That I should write my answer in and around these keywords. Entire answer will take time. I'll just overall structure it and we'll mention the most important judgments so that you'll get an idea. See, overall question, I think it's very easy to understand. It is talking about which one? Constitutionalization of environmental problems by Supreme Court. When you say constitutional of environmental problems by Supreme Court means, in other words, they are clearly telling you how Supreme Court has included environment related issues as part of Constitution. In other words, technically you are referring to which one? Invisible amendments, interpretation of Constitution by Supreme Court, especially with respect to environmental cases. Now that is the context. Of course, you know, and within that itself, what they are clearly telling you, explain with respect to, or explain with the help of relevant case laws. So Of course, major important judgments are there. The landmark judgment is first which one? First is MC Mehta case, 100% you have to write about it. Then if you have forgotten, the very famous Union Carbide case is what? Not limited liability but absolute liability. Then which one? Vellore Citizens Welfare Forum case or Andhra Pradesh Vellore Citizens Welfare Forum case. Even Andhra Pradesh State Pollution Control Board case. Welfare Forum case. In which what they introduced? PPP, Polluter Pays Principle. And then Sundar Rajan case, which Supreme Court introduced which one? Intergenerational equity, in other words, sustainable development, Sundar Rajan case. That is a specific cases. Of course, then in addition, right to clean, I mean, obviously, which one? The Diwali, if you recall that Arjun Gopal case in which Supreme Court put some restrictions on burning of crackers, of course, for in general overall public health also, maybe environmental angle also. That specific, at least some 3 to 4 cases you have to mention. You don't have to write obviously all the law, I mean not necessary also, but landmark, MC Mehta, Union Carbide, and at least one of those other 2 you have to mention. Now obviously in addition what you have to tell, because of that same, so obviously how clean environment, clean air, all of that will be there. Some other examples you have to write, you can write, for example, which one? Polluting industries were shifted to the outskirts of Delhi, and what you call this Bharat emission standards they introduced due to this, and then which one? The public transport in Delhi was shifted to what you call CNG angles, whatever, the oil refineries of Mathura were stopped because of the acid rains on Taj Mahal, like that specific angle you can bring, environmental angle, everything. But again, same as we wrote for right to privacy, what you also highlight, when you include so many things under right to environment, everything broadly, what is the next comes? What are the challenges? Logically you think what all challenges will it create? How will you go ahead with development projects? So many development projects were stopped because of the environmental angle. Assured. So that angle you can bring, and obviously compensations. So much of compensations, penalties will be there. How will you manage those aspects? Assured. Obviously to practically implement it, the pollution control boards, central pollution control board, state pollution control boards have to be very, very strict, but that enforcement has been very weak. That means lastly it also has become what? Paper rights. Positives are there, but even that, because without enforcing, how will you ensure it? Supreme Court can't enforce it. So governments has to come up with laws and policies and programs, everything to implement that. Now look at it, despite telling everything, look at the recent Delhi's air quality index issues. You know, right, some 4 or 5 months back, you have told so many things by Supreme Court itself, but look at what's happening in Delhi even now. Air quality index has gone absolutely to the peak. Then what is the use of declaring everything as right to clean environment? Where is the implementation part then? So that means enforcement is still very, very weak. So that highlights that also you have to mention, because if you only mention what you call this, that this is what is the case, this is what is the importance, where is the challenges, your answer will not become holistic then. I have already told you multiple times, your topper is someone, means if you want to get that 120 plus in GS-2, not any subject, but because we are discussing GS-2, 120 is the scope as of now, you can get 120 plus. So for that what you have to do, make your answer holistic, bring the keywords, write it from as many dimensions as possible, and you cannot skip conclusions, you cannot skip introductions. It has to be as relevant as for all that you have to manage, along with your structuring, presentation part, language part, paper specific language part, everything matters. Only then you can expect 20 plus, or else you go and address all the questions, I mean write all the questions, address the core demand of the question, you can easily expect in 100. 100 you can get, 100, 105. Be a paper you have to complete, address the demand of the question. But 100 is what exactly? Average. Means what you will get an interview call, provided all the other papers also you get that average one. But what you can't get into? Service it's very, very difficult. Sure. So then again you have to come back again, and by the way they are making claims, so you never know. Obviously it has become very, very uncertain. That's why I have to again and again told you, especially those who are going to give mains this time. This I'll stress it again, because so that you understand how important, what kind of an opportunity to have with you. Almost 50 to 60% serious candidates are out of the game. You will never get such a golden opportunity again. Those who are going to write mains this time. Next time what will happen? By the next time what will happen? Every other serious candidate also will get adjusted to this game. Whatever game they introduce this time, they'll get adjusted. So they'll again come back to the game. So again it will become more level playing. This time, huge advantage even if you are a first timer mains writing also. If you are writing mains for the first time also, it's a huge advantage. Please make the best use of it. Don't even think that like, okay, I'm writing first mains, I still don't have one or two mains. Absolutely, it's still fine. So within June, make sure that you are ready. You are still in a very good position. So it's like one different way of destiny giving it for you. It's actually a destiny. So you will not get this opportunity again. Yeah, fine. I think those who are writing mains this time, for them I am telling you. For others, of course, this part will always continue. But the mains angle only I am specifying. Okay, fine. So please note down the question. Note it down. Okay, fine. So let's write the answer for it. The only last 4-5 years I am stressing more. The old previous questions you can go. Of course, you can search and usually you can handle it. Yeah. Start with that. It is talking about constitutionalization of environmental problems. Tell first what do you mean by constitutionalization? That word you explain. Constitutionalization by Supreme Court means. Constitutionalization by Supreme Court means. Constitutionalization by Supreme Court means interpretation of the Constitution. Interpretation of the Constitution and inclusion of a particular provision. Interpretation of the Constitution, inclusion of a particular provision as part of the Constitution through invisible amendments. And inclusion of a provision as part of Constitution through invisible amendments. Through invisible amendments. Simple. For example, Supreme Court has given very broad interpretation for 19 clause 1 subclause A and 21. Supreme Court has given very broad expansion for 19 clause 1 subclause A and Article 21. Very broad expansion for Article 19 clause 1 subclause A and Article 21. Now get to that below. Constitutionalization of environmental problems by Supreme Court. Directly write the case and let's write the significance. Constitutionalization of environmental problems by Supreme Court. Constitutionalization of environmental problems by Supreme Court. Yeah, mention that. First major judgment. Or if you want, because they have mentioned the word as case laws, below that, major case laws. Major case laws. First one, MC Mehta case, right to clean environment. MC Mehta case, right to clean environment. Right to clean environment. Then, Union Carbide case, Bhopal gas tragedy case, in case you don't remember that. Union Carbide case, that is Bhopal gas tragedy case. Absolute liability principle replaced with limited liability principle. Absolute liability principle replaced limited liability principle. Absolute liability principle replaced limited liability principle. Limited liability principle. Then Vellore Citizens Welfare Forum case. Even Andhra Pradesh State Pollution Control Board case also. Vellore Citizens Welfare Forum case. Vellore Citizens Welfare Forum case. Supreme Court introduced polluter pays principle. Supreme Court introduced polluter pays principle. Polluter pays principle. Then Sundar Rajan case. Supreme Court emphasized intergenerational equity or sustainable development. Supreme Court emphasized intergenerational equity or sustainable development. Yeah, I'm giving you 4-5 cases. You remember 2-3 at least, because they're telling you clearly. And the landmark, another one in environment, you would have mentioned it. Godavarman Thirumal Pad case. Intergenerational equity or sustainable development. Sundarajan. Godavarman Thirumal Pad. Broader interpretation or broader definition of which one? Forest. Anything included as forest in government record. Godavarman Tirumala Pad case, broader definition of the term forest. Broader definition of the term forest. That's why they call it as forest case itself. Broader definition of the term forest. Dictionary definition they give. Broader definition of the term forest. Sure, these are the relevant case laws. Now, due to this, now again continue, because you have to tell what? Significance, criticisms, everything. Significance of constitutionalization of environmental problems by Supreme Court. Significance of the constitutionalization of environmental problems by Supreme Court. Means due to that, what all changes happened over a period of time. Yeah, first one. As a list you write, whatever remember, you bring back your environmental angle, but write it as a quality answer. The first one. Polluting industries were shifted to the outskirts of Delhi. Polluting industries shifted to the outskirts of Delhi. Shifted to the outskirts of Delhi. 2. Public transport shifted to CNG. Of course, Delhi. Public transport in Delhi shifted to CNG. Public transport in Delhi shifted to CNG. To CNG. Then national forest policy, national environmental policy, national forest policy, national environmental policy redrafted. Forest policy, national environmental policies redrafted. Then compensatory afforestation. Compensatory afforestation. Campa Act. CAMPA, Campa Act introduced. So the impact of this constitutionalization. Campa Act introduced. So then, what do you call this? It is BS, Bharat Standard. Introduction of Bharat Standards. Introduction of Bharat Standards based on EU norms. Bharat Standards based on EU norms. European Union norms. Then restrictions on burning of crackers during Diwali. Bracket Arjun Gopal case. Restrictions on burning of crackers during Diwali. Arjun Gopal case. Arjun Gopal case. All this is obviously because of the positive impact. Same way, continue below. However, it has also created administrative challenges. It has also created administrative challenges and enforcement problems. Administrative challenges and enforcement problems. And and enforcement problems. Yeah, what are those? First one, major development projects. Major development projects were stuck. Major development projects were stuck due to environmental and tribal concerns. Environmental and tribal concerns. Of course, because always one or other challenge will be there. Example, Niyamgiri issue, Hasdiyo Aranya issue. Niyamgiri issue, Hasdiyo Aranya issue. Niyamgiri issue Odisha, Hasdiyo Aranya Jharkhand. Hasdiyo Aranya issue, Hasdiyo forest. That is one major challenge. And second major challenge. This has remained as a paper right. It has remained as a paper right. Paper right means only on paper it's their theory. It has remained as a paper right. For example, recent Delhi AQI, air quality index issue. Recent Delhi air quality index issue. So where is the clean environment there? Delhi air quality index issue. That's another challenge. But the next one, ease of doing business. Ease of doing business. Ease of doing business is affected due to absolute liability, polluter pays principle. Absolute liability and polluter pays principle. Absolute liability and polluter pays principle. Then of course what? Livelihood, employment concerns. Livelihood, employment concerns for people in Western Ghats. Bracket, Madhav Gadgil report issue. Livelihood, employment concerns for people in Western Ghats due to Madhav Gadgil report issue. Whatever, even the forest angle, Godavarman issue is also there. Fine. Same concerns, obviously. Then what do you have to do? Mention that constitutionalization of environmental problems by Supreme Court. Constitutionalization of environmental problems by Supreme Court. Constitutionalization of environmental problems by Supreme Court has helped India to progress towards achievement of SDGs, Sustainable Development in general. Help India to progress towards achievement of sustainable development, and protect public health. However, it is a responsibility of the Supreme Court. To strike a fair balance between right to clean environment and livelihood development concerns. Strike a fair balance between right to clean environment and development and livelihood concerns to meet the needs of 21st century. To meet the needs of 21st century. Meet the needs of 21st century. Fine. This way you can mention about constitutionalization of environmental problems. Same way, same pattern. If you recall, they asked about which one? Constitutional perspectives. Explain the constitutional perspective of gender justice. Assured. And specifically what they have told? Relevant constitutional provisions as well as case laws. Both you have to mention. When you say constitutional provisions, in other words, broadly that are asking you about which one? Specific articles, constitutional provisions with respect to which angle? Gender justice. When you say gender justice, to make your answer more holistic, you can also mention about which one? One is women angle and wherever possible. Transgender also. No need to mention only and only about women. Of course, specific constitutional provisions are not there with respect to transgenders, but what you can mention? Case laws you can mention with respect to transgenders, and of course what you can also mention? Maybe the act, transgender, rights of transgenders act, so that also you can mention. So here again, detailed law, answer not necessary, only the information part what is necessary we can mention. Just put the overall question, we will only mention the, because again you keep on writing the arguments, everything, this will take time for this. Not a very analytical question, directly you can write. In addition, you can also add what, after you address the constitutional provisions, case laws, what are the major government acts, what are the major government policies, what all achievements has happened. This is kind of social justice also linked. With respect to women, whatever challenges, everything you can bring. Mention that directly, only the answer part, because the detailed answer not possible, only the information. First mention constitutional provisions for gender justice. Constitutional provisions for gender justice. And that, women. So many are there. So they can ask any, like how we wrote constitutional provisions with respect to reservations, almost like that. So specifically women angle you have to bring, and that fundamental rights, and because we can divide that, and then DPSP, and then fundamental duties, like that. Just organizing your answer points better in the fundamental rights. Of course, broadly Article 14. Article 14, one broader one. Then Article 15, Clause 1, prohibition of discrimination on gender. 15, Clause 1, prohibition of, even Clause 2 also in a way, Clause 1, Clause 2, prohibition of discrimination based on gender. Other angles are there, but here we have to talk about gender angles. 15, Clause 1, 15, Clause 2, prohibition of discrimination based on gender. 15, Clause 3, special provisions for women. Special provisions for women. 15, Clause 3, special provisions for women. Right? Then the 16 specifically for women it's not there. 17 is not there. 18. What else is there? 19. The fundamental rights, I think these are the only ones. Is there anything else for women specifically under fundamental rights? Okay, that's largely 23, 20, 23. You can tell that traffic, what you call this prostitution angle, all of them is gender justice, but that's very general. In Clause 4, if you want reservations in some states, you can tell indirectly. You can say that below. 16 Clause 4, reservations for women in many states, multiple states. Even in Karnataka, if they have seen women reservations. 16 Clause 4, reservations for women in many states. Reservation for women in many states. Yeah, that is fundamental rights angle. Yeah, then DPSP angle, women specific. DPSP, Article 42. Maternity benefit for women. Article 42, maternity benefits for women. Maternity benefit for women. Then fundamental duties. Article 51, capital A. Fundamental duties, Article 51, capital A. Renounce practices derogatory to dignity of women. Renounce practices derogatory to dignity of women. Renounce practices derogatory to dignity of women. Right? That is below that, which one? That is fundamental duties angle. Yeah, this one. Sorry, 330 capital A, 332 capital A. Reservation for women in Lok Sabha and Assembly. 330 capital A, 332 capital A. 106th Amendment. Women reservation in Lok Sabha and Assembly. 106th Amendment. Maybe that is the context, because 2023 there was there. If you recall, both the 23 questions in a way was related to women. 106th Amendment 2023, women reservation in Lok Sabha Assembly. Then of course again where? 73rd Amendment, 74th Amendment, women reservations. 73rd Amendment, 74th Amendment, women reservation. 73rd, 74th, 1992, women reservation. 243 D and T is for SC ST. I think this is C. I'm not sure, you go and check out. Generally 243, but specifically is it C or E, and if the confusion is there, you go and check and like that. That is a women angle, women related constitutional provisions. Of course, they as well begin, because then we'll come to the case law specifically. Then below that, okay, judgments wise, if you want, okay. Case laws, anything they are telling, case laws. Women will finish, then we'll go to transgender. Case laws. So many are there. One of the few landmark is written. Vishaka guidelines. Vishaka from state of Rajasthan. Of course, you know which one. Protection of women against sexual harassment at workplace. Protection of women against sexual harassment at workplace. Protection of women against sexual harassment at workplace. Sexual harassment at workplace. Then Shakti Wahini case. Honor killing. Honor killing. Declared rarest of rare case, whereby death penalty. Shakti Wahini case. Honor killing declared. That's what is your Khap Panchayat kind of question. Honor killing declared rarest of rare case, thereby leading to death penalty. Thereby leading to death penalty. Then of course, Shabano case. Shabano case. Muslim divorced women eligible for alimony compensation. Shabano case. Muslim divorced women eligible for alimony. ALIMONY. Eligible for alimony. Then Shaira Bano case. Triple Talaq declared unconstitutional. Only women related you have to write. Shaira Bano case. Triple Talaq declared unconstitutional. Triple Talaq declared unconstitutional. Then Sabrimala case. All India Young Lawyers Association case. Women given entry into Sabrimala temple. All India Young Lawyers Association case. All India Young Lawyers Association case. Women given entry into Sabrimala temple. Women given entry into the Sabrimala temple. This women angle, constitutional provision, case law. Then transgenders. let's say social, when you read, when you know social justice, so many other provisions you can bring here. Significance related one, what all progress has happened, what are major policies, laws that are brought by the parliament and government, everything. Transgender rights or transgenders. Of course, constitutional provisions, what you have to mention, there is no specific provision with respect to transgenders. There is no specific provision with respect to transgender. That is not there. No specific provision, constitutional provision we are telling. There is no specific constitutional provision with respect to transgenders. What has done? Parliament has passed Rights of Transgenders Act. Parliament has passed Rights of Transgenders Act. It's the only major we have. Parliament has passed Rights of Transgenders Act. But of course, what do we have? Under that, case laws are there, that you can write. Case laws. Transgender related case laws. Anytime it can help you. Case laws. Of course, under that first one. Yeah. Before now, okay, NASA also you can write before that. NAS Foundation case. Overall, everything you write. NAS, for that, when you revise it, everything should be there at one place. NAS Foundation case, Supreme Court, it's not Supreme Court, sorry, Delhi High Court. Delhi High Court decriminalized homosexuality. In other words, Section 377 unconstitutional. Delhi High Court decriminalized homosexuality. This is not transgender rights, but just to keep it in mind. Suresh Kumar Kaushal case, Supreme Court recriminalized it. It's not upholding justice, but just to keep it in mind as an information sake. Suresh Kumar Kaushal case, Supreme Court recriminalized homosexuality. Supreme Court recriminalized homosexuality. Supreme Court recriminalized homosexuality. Then, Navtej Singh Johar case, right to gender identity, fundamental right under 21. Navtej Singh Johar case, right to gender identity is a fundamental right under 21. Right to gender identity is a fundamental right under Article 21. Then Supriyo case, this is not again gender justice, but just to mention that Supriyo case, same-sex marriage not allowed for transgenders. Same-sex marriage not allowed for transgenders. Overall cases related to transgenders. Same-sex marriage not allowed for transgenders. Supriyo case. Right? That is broadly about your, which one? Gender justice angle. So overall information is actually when you write an answer, you need not write each and everything. I have given you so that with whatever you want, you remember that. Then of course you have to write because of all these things, what all practically, how has it been implemented, what all progress has been made, then some whatever limitations are there, that angle. So that you need to bring. It's a kind of your polity and social justice combination question. Then the last year's question. Yeah, note on the question. Again Article 21, again privacy. Structuring part I will tell, and only this DNA, again, this will not get repeated, don't worry. This is not a theme, but just to understand the structuring part. Broadly, there are two subparts of the question. Right? Look at it. First subpart, I don't have to tell. Multiple times you have already written now itself. Look at it. Right to privacy, intrinsic, integral part of which one? Same. Right to life and personal liberty, inherently protected under 21. Explain. So in that means in your first subpart, very clear. What you have to write about? Right to privacy, how is it part of Article 21, which case the same, case Puttaswamy case, and then what all is part of that. Remember, right to privacy itself includes whatever you have written. That list, that's your first subpart, very clear. There is no problem itself. Then comes your second subpart. What are they asking about? Discuss the law relating to DNA testing. Means the legal aspect you have to mention. Of course, then you can mention one or two Supreme Court cases also if you are. Law related to DNA testing of the child in the womb to establish its paternity. So DNA testing of the child in the womb. So that is your second part, second subpart. This is the part. If you have addressed this part, automatically answer would have been there. Of course, this part, second part, chances of getting repeated is not there. For simple reason, I think during that year there was some case or something was going on, issue was going on with respect to the DNA testing, everything. Hence, in that context, they have added it to the right to privacy angle. That's it. But of course, first subpart I will not make you write again because it's already written multiple times. I don't have to tell. Same, I think understood subpart, right? Only the second part, just put the heading there. Just for the structuring. What you can do, you can go back and when you start writing, if you want to write it as again a PYQ, you write completely, right to privacy, what is it, which case Supreme Court introduced it, what all does it include, and then you write the subpart 1 also, and then you write subpart 2 also. Here, because you have already written it, I am not making you write again, just put this heading, DNA testing of the child in the womb. DNA testing of the child in the womb. DNA testing of the child in the womb. Legal provisions mentioned that below. PCPNDT Act. PCPNDT Act. If you have forgotten the overall name form, please write Preconception PCPNDT Act. Preconception, Prenatal Diagnostic Techniques Act. It's Prevention and Regulation Act. Preconception, Prenatal Diagnostic Techniques Act. Diagnostic Techniques Act. So what does it tell? DNA testing of the child is not allowed. DNA testing of the child is not allowed except in case of medical emergency or court orders. Except in case of medical emergency or court orders. So this time what it will, question will not get repeated. Maybe these points you can use. So that's what you have to be smart enough to use the same points in multiple aspects. Maybe you can mention it in your ethical dilemma somewhere in ethics. Maybe you can mention it maybe in GS-2 itself somewhere. Next year if they ask, this year again if they ask you some privacy question, then what you can tell? There one of the points can be what? That this is also, say, look at it, it's a challenge. See, look at the challenges, what is it? It is a right to privacy of the mother. It is a right to know of the father. It is the right to be left alone, or it is the right to be dignity of the child. Which is more important? So you can't judge. It's very tricky question. But always and always, broadly, I mean, we can say 80-90% of the times, always which gets more priority? Privacy gets more priority. Unless, as we told, maybe some medical emergency issues or something like that, or to settle some, let's say, disputes, as I mentioned here. Not just paternity angle, extension of that, maybe some property disputes, or in that context, so many things they have to settle. At that time, of course, right, you have to establish that so-and-so is the, if you have heard, famous politician was there, called as N.C. Tiwari, the former CM of UP. He was very famous for this, all this DNA testing angle, because some 4 or 5 people had put a case against him saying he is my father, but he was not agreeing to anybody. Now, whatever, that's a very famous, he is very famous in India's history for his, whatever, I think you would have understood that kind of angles. So that is a paternity disputes. Fine, that's not necessary for us. That is PCPNDT angle. That is one angle. Two, Indian Evidence Act. What now it is replaced as the Nagarik, sorry, Sakshi Sanhita. Indian Evidence Act. Child within a marriage is considered as legitimate unless there is contrary evidence. Means you should assume that it is a legitimate child itself. Child within a marriage is considered as legitimate unless there are contrary evidences. Unless there are contrary evidences. Contrary evidences. Good. Then Supreme Court's one. Babani Prasad, BHA-BANI. Babani Prasad Jena, JENA. BHA-BANI. Babani Prasad Jena case. Babani Prasad Jena, JENA. Jena case. Right to privacy. Right to privacy is more important. Right to privacy is more important. Hence, DNA testing cannot be conducted routinely. Means it's like not like, okay, whenever someone requests, you just can't keep on giving the permission. DNA testing cannot be allowed routinely, conducted routinely. Cannot be allowed routinely. Cannot be allowed routinely. Right? That's another one. Now, what is the legal issue? Then again here, it creates a legal conflict between. It creates a legal conflict between right to privacy of the mother. Creates a legal conflict between right to privacy of the mother, right to know of the, you can say in general, parents or father or whatever, family, right to know of the father and family. Right to dignity of the child. Right to dignity of the child. What Supreme Court does? Right to dignity of the child. Supreme Court largely favors right to privacy. Largely favors right to privacy. Decides it on a case-by-case basis. And decides it based on case-by-case basis. Maybe sometimes they may allow it for paternity disputes. If you want, you can actually mention that. And decides it on a case-by-case basis. For example, it allowed, Supreme Court allowed DNA testing to resolve paternity dispute in NC Tiwari case. Supreme Court allowed DNA testing to determine paternity in NC Tiwari case. Yeah, that's a necessity for a fair balance. That's the second part. First part is obviously there. This environmental angle, see how broadly they keep giving. Now this year, as I told, 2-3 issues are there. Discuss that later. Other question, if in case, let's write it, and then the current affairs top. Okay, this I think you can only directly write. Simple basic question. If you have forgotten, I'll just sum up once. Try to write an answer now itself. For 2 aspects. Which one? Recall. Even if you have revised for prelims also, you can easily recall. Right to movement. Tell the article. 19 clause 1. Subclause D. Subclause E. right to residence throughout the territory of India, freely available, correct, to the citizens, obviously because entire 19 is for citizens, but they are not absolute, assured. So that means it's a very static question, nothing extraordinary, maybe in the context of COVID or something they might have given. I'll tell you the structure again. See, first in the introduction, what you can tell, you can talk about that fundamental rights are called as the, whatever way you want, you do it. I'm just telling you one way. They are called as a Magna Carta 1, mention that it is mentioned in part 3, article 12 to 35, that is broader angle. Then come to the core angle, right to movement and residence is broadly part of which one? Freedom of movement, okay, or else to the heading as right to movement. Both you address it both separately. Right to movement, 19 clause 1 subclause D. And that what you do? First briefly explain what is this right to movement. If you recall, it is a freedom for all the citizens to move freely throughout the territory of India. And why is it necessary? It is necessary to ensure, obviously what? Exactly, to ensure unity and integrity of India, facilitate migration of the people for whatever purposes, jobs, education, travel, tourism, whatever you call it as. For all that it is necessary. Now short, then what you have to tell? However, what are there? Certain reasonable restrictions are imposed on two grounds. Which one? General public interest and B. First is general public interest. First is general public interest, second one is interest of ST. Assured. And then for that you have to mention some case laws or some examples. Of course, you know, example, if you recall which all cases. Simple case you tell. If you want example, like for example during COVID itself, right to free, what do you call this, right of movement of people was restricted for which grounds? Public interest. Or if you want the STA, which is scheduled tribe angle, you tell. Fifth schedule, sixth schedule, inner line permit provisions restrict the freedom of movement of, or freedom of movement in where, which on the interest of scheduled tribes. Yeah, that is one angle. Then you put the heading as which one? Freedom of or right to residence. And then if you recall, there are two components within it. Which one? One is temporary, that is residence. Two, settlement, permanently settled. And you can tell about that also. Why is it necessary? Again, same. Unity and integrity, people should be allowed to go, move anywhere and settle anywhere. Again, same. It is also subjected to. Yeah, and then mention again some restrict. For example, in wherever, let's say, national parks are there or something like that, in the general public interest or environmental angle, residences are not allowed. For ST angle, I've already told you, outsiders are not allowed to go and permanently settle in 5th schedule, 6th schedule areas that you mentioned. And then broadly conclude why that kind of balance is ensured, all of that. Typical static question. You understood the structure, right? First in introduction, write about fundamental rights, where is it found? Then put the heading as right to movement. Tell first what is it, why is it important, reasonable restriction, Supreme Court cases, examples. Same pattern, right to residence, article, what is it, importance, reasonable restrictions, some cases or Supreme Court judgments, whatever you have. Then broadly try to conclude. Nothing analytical, typical static question. Few of you might have already written answers for it in your normal class also, but please note down the question, take it as a 10 marker. I've told you structure also, I've told you content also. Write that. Done? Start. 8 minutes you have. Try to write within time. As I keep telling, never ever write without time from now on. Always keep it in mind. So first point, as I keep telling, so from now on, whenever you write, because already basics, everything will be done, even if you're giving this mains or next mains, whatever it is, please make sure that even when you write in your homes or libraries or PGs, wherever it is, so you have to keep a clock and write. So that is first most important one. Let's say you're writing a 10 marker, ideally 7, okay, in the initial chance keep it as 7 minutes 30 seconds or 8 minutes. 15 marker, ideally 10 minutes, maybe let's say you keep 1 minute extra, you keep it as which one? 11 minutes also it's fine, but start practicing by keeping timer, clock, or else you will not get to know the challenge. And just don't keep on writing until the what you call is the clock rings or anything, say timer rings or anything like that. Keep watching, let's say, or is it like what 2 minutes left, 1 minute left, how much I mean what position are you in, will judge yourself like, okay, can I finish 2 sides or not? And if in case you are not able to finish 2 sides, at least try to stick to which one? 1/3/4. Or if it's a 15 marker, when you get to know that, okay, it's already 7 minutes, it's already 8 minutes, I only have 2 minutes left, I only have 3 minutes left, okay, fine, I'm still in, okay, let's say even 2 sides I have not completed, that means 3 sides you can't write. Then don't just scribble and what you call is completely put yourself in a negative impression in the eyes of evaluator. At least then tell yourself what, okay, fine, I can't write 3 sides, let me write 2.5 sides, let me write 2 sides and 3/4 of another third side. So you should tell yourself, because always understand, you should strategize according to your strengths and weakness. Yes, ideally you should write 2 sides, ideally you should write 3 sides, because space management is also matters a lot actually. But sometimes what happens, maybe speed issue, maybe let's say for example that particular question you are not able to generate points, maybe it's very vague, you don't have so many specific points, whatsoever, so many challenges will be there. Don't force yourself to write the entire side, because here, I mean, UPSC doesn't change the sides everything so easily. Even if they make it as I keep telling which one, even if they start asking 5 markers, if they try to change the pattern a little, 5 markers means what? 1 side. So 5 mark, always keep it in mind, 1 side. Let's say, sir, what if they go back to the 12.5 marks era? Then they'll make it as what? 2.5 side. That's how it is. 5 mark means 1 side. If it is only 5 mark, 1 side. If it's 10 mark, 2 side. 3 sides, 15 marker, 3 side. 12.5 mark, 2.5. That is 2.5 sides. So accordingly you strategize it. Don't force yourself to completely fill the entire space, because presentation also matters. Just because you just keep on filling the space, what if you affect your presentation itself? So that negative impression the evaluator will carry to which one? Forget about that question, that particular question, he will also carry that too. Next question also, you will also get half mark less there. Assured. Or you just keep on writing, conclusion you don't write, abruptly you end, and then you move to next question, that's also negative impression. Consistency throughout the paper is important. Not necessary that you should mandatorily fill all the space. Ideally, yes, I am not telling you no. But keep your strengths, weakness also in mind, because both time management, space management, speed management, organization, structure, presentation, paper specific language, the what do you call it, flow of the paper, I mean, how do you write it? Flow means what? Evaluator should be able to easily go through your answer, as I told yesterday, all of that matters. It's like combination of everything, it's not like only 1 or 2 aspects. Everything matters. If you manage everything, you will get it like that. Same way, consistency, you go and look at any major topper's answer. If you go and all of a sudden, let's say go open question number 13, 14, you will not find like, okay, so did he, like for example, if a normal person who is writing, let's say what you call, not so much of answer writing practice, if you write it, evaluator will easily get to know, okay, you started with question number 1. That's why by the time you came to question number 15, you did not have time. That's why what you will do there? Quickly just keep on scribbling and then write. Evaluator will get to know you have not managed time well. That's a negative impression. That's why if you open any topper, you can go direct, all of it randomly open question number 5, randomly open 7, randomly open 14. More or less, what you can't even tell which one did she write first, which one did he write. Let's say at the end of 2.5 hours, 2 or 45 minutes, you will not be so easily able to understand it, not be able to even identify. So that indicates what they have done. They have managed time so beautifully that more or less every question equal importance is associated. Because it's not like one question they'll give you more mark, one question they'll give you less mark. There's nothing like that. Maximum they'll give you 50% only. As I told, even if you write half an hour, 10 markers, They'll not give you 10 out of 10. You'll still get 5 only. That's why allocate equal time for every question. Don't allocate so much of time to one or few question. You compromise other question. You assume that those few question I had so much of content. I'll write all the points. Still 5 mark only. So that's why manage it well. Consistency throughout the paper is very important to get into top 100, top 50, or to get 120 plus in GS2 or 120, 130 sometimes in GS4. All of that matters on lot of factors, not just only one factor. Right? Okay. Then other questions. Again, now we need not write answers for it. You note down the questions. Still 2022. Let's go back from reverse order. 2014, 13, 15. Okay, note down the same ones. It's fine. First note down 15. Will not write. I think you'll be knowing. Just go, you search and note. If you want to practice it, practice it. It won't get repeated again. And current issues will come back in the next section, morning afternoon session. Whatever left out, current affairs related, fundamental rights, as I told. Die with dignity, personality rights, doctrine of essential practices I left out, freedom of religion. Anyhow, Shabrimala case is again under discussion. Then 14. This is for your practice. Small additions, that's it. Pay a single case. Section 66A declared unconstitutional. Then, as I told, some current issues are there's maybe some 3-4 maximum. So that we'll discuss in the related to fundamental rights. I'm telling. We'll come back by 3 o'clock. We'll discuss that, and we'll start with another most important topic: either judiciary or parliament. Parliament will keep it like maybe federalism. We'll do federalism first. Federalism, local bodies, everything, and then we'll come back to your judiciary, and then parliament, elections, and then at the end we'll keep those small topics like separation of power, comparison, RP Act, all of that we'll keep it to the end. Right, come back by 3 o'clock. Here itself, same.